Question 1. Compliance review shows an Alabama-based investment firm is considering advising its clients on investing in European Union domiciled investment funds. Considering the specific regulatory framework of the European Union, which of the following approaches best ensures compliance and client protection for Alabama investors seeking to access these EU investment opportunities? Option A. Rely on general international investment best practices and the reputation of EU fund managers, without undertaking specific research into current EU regulatory requirements for non-EU investors. Option B. Prioritize the client's immediate access to potentially higher-yielding EU funds by advising them to invest directly without a thorough review of the specific regulatory implications under EU law. Option C. Assume that compliance with U.S. federal securities laws, including those overseen by the SEC, is sufficient for offering EU investment products to Alabama residents, given the client's domicile. Option D. Conduct a detailed comparative analysis of relevant EU directives, such as UCITS and AIFMD, alongside applicable U.S. federal and Alabama state securities laws, to identify all registration, disclosure, and investor protection requirements for both jurisdictions. Correct answer is D. Conduct a detailed comparative analysis of relevant EU directives, such as UCITS and AIFMD, alongside applicable U.S. federal and Alabama state securities laws, to identify all registration, disclosure, and investor protection requirements for both jurisdictions. Explanation. This scenario presents a professional challenge due to the inherent complexities of cross-border investment and the need to navigate differing regulatory landscapes. Specifically, advising an Alabama-based client on investments within the European Union requires a deep understanding of both U.S. securities law, as the client is U.S.-based, and EU investment regulations. The challenge lies in identifying potential conflicts, ensuring compliance with all applicable rules, and safeguarding the client's interests while adhering to professional standards. Careful judgment is required to balance the client's investment objectives with the stringent regulatory requirements of the EU. The best approach involves a comprehensive comparative analysis of the regulatory frameworks. This entails meticulously examining the EU's directives and regulations governing investment funds, such as the Undertakings for Collective Investment in Transferable Securities, UCITS, and Alternative Investment Fund Managers Directive, AIFMD, and comparing them against relevant U.S. regulations like the Investment Company Act of 1940 and the Securities Act of 1933. The focus should be on identifying how an Alabama investor can legally and efficiently access EU investment products, considering registration requirements, disclosure obligations, and investor protection measures in both jurisdictions. This approach is correct because it prioritizes a thorough understanding of all applicable laws, ensuring that the advice provided is legally sound, compliant, and in the best interest of the client. It acknowledges the dual regulatory environment and seeks to bridge any gaps or conflicts proactively. An incorrect approach would be to solely focus on U.S. regulations and assume that compliance with U.S. law automatically satisfies EU requirements. This fails to recognize that EU member states have specific rules for offering investment products to their residents and for managing EU-domiciled funds. Such an approach would likely lead to non-compliance with EU directives, potentially resulting in regulatory penalties, reputational damage, and significant financial losses for the client. Another incorrect approach is to rely on general knowledge of international investment without conducting specific research into the current EU regulatory landscape. The EU's regulatory framework is dynamic and subject to change. A superficial understanding could lead to outdated or inaccurate advice, exposing the client to unforeseen risks and legal complications. A third incorrect approach would be to prioritize the client's desire for specific EU investments without adequately assessing the regulatory hurdles and associated costs. While client objectives are important, they must be pursued within the bounds of the law. Ignoring or downplaying regulatory complexities to meet a client's immediate wishes is ethically unsound and professionally irresponsible. The professional decision-making process for similar situations should involve a structured multi-step approach. 1. Understand the client's investment objectives and risk tolerance. 2. Identify the target investment jurisdictions and products, in this case, EU investment law. 3. Conduct thorough research into the specific regulatory frameworks of both the client's home jurisdiction, Alabama/US, and the target investment jurisdiction, EU. 4. Perform a comparative analysis to identify areas of overlap, divergence, and potential conflict. 5. Assess the feasibility and compliance requirements for the proposed investment strategy. 6. Develop a compliant investment plan that addresses all regulatory obligations. 7. Clearly communicate all risks, costs, and regulatory considerations to the client. 8. Seek specialized legal or compliance advice if necessary. Question 2. The assessment process reveals a need to understand the foundational influences on international investment law as it pertains to Alabama's historical engagement with foreign capital. Considering the period before the widespread adoption of comprehensive multilateral investment agreements, which of the following best describes the primary historical drivers shaping international investment law relevant to Alabama's development? Option A. The development of international arbitration mechanisms primarily focused on resolving commercial disputes between private parties. Option B. The emergence of multilateral trade agreements and regional economic blocs focused on market access for goods and services. Option C. A series of bilateral investment treaties and customary international law principles concerning the treatment of foreign nationals and their property. Option D. The evolution of Alabama's specific state-level statutes and regulations governing foreign ownership of land and businesses. The correct answer is C. A series of bilateral investment treaties and customary international law principles concerning the treatment of foreign nationals and their property. Explanation. The assessment process reveals a scenario requiring a nuanced understanding of the historical evolution of international investment law, specifically within the context of Alabama's engagement with foreign direct investment. The professional challenge lies in accurately identifying the foundational influences that shape the current regulatory landscape, distinguishing between early, often bilateral, approaches and the later emergence of multilateral frameworks. This requires careful judgment to avoid anachronisms or misattributions of influence. The best professional approach involves recognizing that early international investment law in the United States, including Alabama's historical context, was largely characterized by a series of bilateral investment treaties, BIT, and customary international law principles, particularly concerning the treatment of aliens and their property. These early agreements and norms predated the comprehensive multilateral frameworks that emerged later. This approach is correct because it accurately reflects the historical progression, acknowledging the foundational role of bilateralism and customary law before the advent of more complex multilateral regimes. Alabama, as part of the U.S., would have been subject to and influenced by these early bilateral arrangements and the evolving customary international law concerning foreign investment protections. An incorrect approach would be to immediately focus on multilateral agreements like the WTO agreements or specific regional trade pacts as the primary historical drivers of international investment law's development in Alabama. While these later frameworks are significant, they represent a more recent evolution and do not capture the initial historical trajectory. This fails to acknowledge the foundational period where bilateralism and customary law were the dominant forces shaping international investment relations. Another incorrect approach is to solely emphasize the role of domestic Alabama state law in the historical development of international investment law. While state laws can implement or reflect international obligations, they are generally not the primary drivers of international investment law's historical development. International investment law is primarily shaped by treaties between sovereign states and customary international law, which then influence domestic legal frameworks. Attributing the historical development primarily to state-level legislation misunderstands the international nature of the subject. A further incorrect approach would be to conflate the historical development of international trade law with international investment law. While related, they are distinct fields with different historical trajectories and regulatory focuses. Focusing on trade liberalization as the sole historical driver of investment law development overlooks the specific concerns and mechanisms that have characterized investment protection and promotion throughout history. Professionals should employ a chronological and hierarchical reasoning process. First, identify the earliest forms of international legal norms and agreements that govern foreign investment. Second, Consider how these evolve through bilateral treaties and customary law. Third, analyze the emergence and impact of multilateral frameworks. Finally, understand how these international developments were reflected or implemented within the specific domestic legal system, such as that of Alabama. This systematic approach ensures an accurate understanding of the historical forces at play. Question 3. The risk matrix shows a heightened probability of government intervention and potential nationalization of key industries in Country X, a jurisdiction where an Alabama-based technology firm is considering a substantial direct investment. Considering the Alabama-Alabama Bilateral Investment Treaty, BIT, which approach best safeguards the Alabama firm's investment against potential adverse actions by Country X's government, particularly concerning the treaty's provisions on expropriation and fair and equitable treatment. Option A. Rely on the general principles of international law regarding sovereign immunity and the protection of foreign investment, assuming these will automatically extend adequate protection to the Alabama firm's assets in Country X. Option B. Focus primarily on the property rights protections afforded under Alabama state law, assuming that these domestic legal safeguards will be sufficient to protect the investment against any actions by Country X's government. Option C. Conduct a detailed review of the expropriation and fair and equitable treatment clauses within the Alabama-Alabama BIT, researching relevant international investment arbitration jurisprudence for interpretive guidance, and assessing how these provisions apply to the specific nature of the proposed investment and the political risks identified in Country X. Option D. Adopt a wait-and-see approach, monitoring the political situation in Country X and only initiating legal action or seeking treaty protections if an actual expropriation or clear violation of fair and equitable treatment occurs. The correct answer is C. Conduct a detailed review of the expropriation and fair and equitable treatment clauses within the Alabama-Alabama BIT, researching relevant international investment arbitration jurisprudence for interpretive guidance, and assessing how these provisions apply to the specific nature of the proposed investment and the political risks identified in Country X. Explanation: the risk matrix shows a potential for significant political instability in Country X, a nation with which Alabama has recently signed a bilateral investment treaty, BIT. This instability raises concerns about the security of investments made by Alabama-based companies. The core challenge for an Alabama-based investor lies in understanding how the Alabama-Alabama BIT, specifically its provisions on expropriation and fair and equitable treatment (FET), might protect their investment in the face of such instability. Navigating these provisions requires a nuanced understanding of international investment law as applied within the framework of Alabama's treaty obligations and domestic legal principles. The best approach involves a thorough analysis of the specific language within the Alabama-Alabama BIT concerning expropriation and FET, cross-referenced with established interpretations of these clauses in international investment arbitration. This includes examining definitions of expropriation, both direct and indirect, the conditions under which it might be permissible, e.g., for a public purpose, non-discriminatory with prompt, adequate, and effective compensation, and the scope of fair and equitable treatment, which typically encompasses a spectrum of protections including due process, protection from arbitrary conduct, and legitimate expectations. Understanding how Alabama's treaty obligations translate into actionable protections for its investors is paramount. This approach aligns with the principle of upholding contractual and legal commitments, ensuring that Alabama-based investors can rely on the protections afforded by the treaty. An incorrect approach would be to assume that general principles of international law automatically apply without considering the specific terms of the Alabama-Alabama BIT. This fails to acknowledge that BITs are bespoke agreements that define the precise scope of protections. Relying solely on domestic Alabama law regarding property rights would also be insufficient, as international investment treaties create obligations that transcend national borders and often provide broader protections than domestic law alone. Furthermore, adopting a reactive stance, waiting for an actual expropriation event before seeking legal recourse, ignores the proactive due diligence and risk mitigation that are essential when investing in potentially unstable environments. This passive approach fails to leverage the preventative and protective aspects of the treaty. Professionals should employ a structured decision-making process that begins with a comprehensive review of the relevant BIT. This involves identifying the specific treaty provisions at issue, researching relevant case law and scholarly interpretations, and assessing the factual circumstances of the investment against these legal standards. Risk assessment should be ongoing, and mitigation strategies should be developed in consultation with legal counsel specializing in international investment law, considering the potential application of treaty protection. Question 4. Implementation of a proposed large-scale renewable energy project in rural Alabama, financed by a foreign entity, necessitates a comprehensive review of its legal standing. The Foreign Investors Council has presented arguments suggesting that certain provisions within a relevant multilateral investment treaty, MIT, to which the United States is a signatory, guarantee specific protections and dispute resolution mechanisms that supersede Alabama's standard permitting and land use regulations. The Alabama Department of Commerce is tasked with assessing the project's viability and ensuring compliance with all applicable laws. Which of the following approaches best navigates this complex legal landscape? Option A. Conduct a thorough legal analysis of Alabama's specific statutes and administrative regulations governing renewable energy projects, land use, and foreign investment, while simultaneously evaluating how the provisions of the applicable MIT interact with and are potentially implemented or modified by these domestic laws. Option B. Disregard the MIT entirely, focusing solely on Alabama's existing permitting and land use laws, on the premise that state law is the exclusive governing framework for domestic development projects. Option C. Prioritize the interpretation and application of the MIT's provisions as presented by the Foreign Investors Council, assuming these international guarantees automatically override any conflicting state-level regulations. Option D. Seek an immediate opinion from the U.S. Department of State regarding the MIT's applicability, without first conducting an independent assessment of Alabama's specific legal requirements for the project. The correct answer is A. Conduct a thorough legal analysis of Alabama's specific statutes and administrative regulations governing renewable energy projects, land use, and foreign investment, while simultaneously evaluating how the provisions of the applicable MIT interact with and are potentially implemented or modified by these domestic laws. Explanation. This scenario presents a professional challenge due to the inherent complexities of international investment law, specifically concerning multilateral investment treaties, MITs, and their application within Alabama's regulatory environment. The core difficulty lies in balancing the investor's expectations, potentially shaped by the MIT, with Alabama's specific statutory and common law framework governing foreign investment and property rights. Misinterpreting or misapplying the MIT could lead to significant legal disputes, financial penalties, and reputational damage for the state. Careful judgment is required to ensure compliance with both international commitments and domestic legal obligations. The best approach involves a thorough legal analysis that prioritizes Alabama's governing statutes and regulations, while simultaneously considering the interpretive guidance and potential implications of the relevant MIT. This approach recognizes that while MITs provide a framework for international investment, their enforceability and application within a specific U.S. state are ultimately governed by state law and federal law that implements the treaty. Therefore, understanding how the MIT's provisions interact with and are potentially superseded or modified by Alabama's specific real estate development laws, environmental regulations, and corporate governance statutes is paramount. This ensures that any investment decision or action taken is legally sound under both domestic and international legal considerations, minimizing risk and upholding Alabama's legal integrity. An incorrect approach would be to solely rely on the broad principles outlined in the MIT without critically examining Alabama's specific legal landscape. This could lead to actions that, while seemingly compliant with the MIT's general intent, violate specific Alabama statutes or administrative rules, rendering the investment vulnerable to legal challenge. Another flawed approach would be to disregard the MIT entirely, assuming that state law is the only operative legal framework. This ignores Alabama's potential obligations under the treaty and could expose the state to international arbitration or diplomatic disputes, undermining its attractiveness to foreign investors. Finally, attempting to interpret the MIT in isolation from any established Alabama legal precedent or regulatory interpretation risks creating an inconsistent and potentially unenforceable legal position for the state. Professionals should adopt a hierarchical decision-making process. First, identify all applicable Alabama state laws and regulations relevant to the investment. Second, identify the specific MITs to which the United States is a party and which might apply to the proposed investment. Third, conduct a comparative analysis to understand how the MIT's provisions align with, differ from, or potentially modify the application of Alabama law. Fourth, consult with legal counsel specializing in both international investment law and Alabama state law to obtain a comprehensive understanding of the legal implications and risks. This structured approach ensures that all relevant legal obligations are considered and that decisions are made with a clear understanding of the legal framework. Question 5. To address the challenge of facilitating a significant foreign direct investment into an Alabama-based technology startup under the terms of the Alabama-Mississippi Trade Partnership Agreement, AMPTA, what is the most prudent course of action for an investment advisor to ensure compliance with both the AMPTA and the Alabama Securities Act? Option A. Conduct a thorough review of the AMPTA provisions related to foreign investment and dispute resolution, cross-referencing these with the registration, disclosure, and anti-fraud requirements of the Alabama Securities Act, and seek expert legal counsel to interpret any potential interactions or specific mandates. Option B. Proceed with the investment, assuming that the AMPTA provisions for foreign investment protection automatically exempt the transaction from the standard registration and disclosure requirements of the Alabama Securities Act. Option C. Focus solely on meeting the notification and reporting requirements outlined in the AMPTA for foreign investors, without independently verifying if these satisfy the disclosure obligations mandated by the Alabama Securities Act. Option D. Advise the foreign investor to structure the investment in a manner that avoids any direct interaction with Alabama securities regulations, relying solely on the AMPTA framework for legal guidance. The correct answer is A. Conduct a thorough review of the AMPTA provisions related to foreign investment and dispute resolution, cross-referencing these with the registration, disclosure, and anti-fraud requirements of the Alabama Securities Act, and seek expert legal counsel to interpret any potential interactions or specific mandates. Explanation. Scenario analysis. This scenario is professionally challenging because it involves navigating the complexities of international investment agreements, specifically the Alabama-Mississippi Trade Partnership Agreement, AMPTA, while simultaneously adhering to the Alabama Securities Act. The core challenge lies in reconciling the potential benefits of foreign investment with the regulatory obligations designed to protect Alabama investors and maintain market integrity. A professional must exercise careful judgment to ensure compliance with both the international agreement and domestic securities law, avoiding actions that could lead to regulatory penalties, reputational damage, or harm to investors. Correct approach analysis. The best professional practice involves a thorough review of the AMPTA provisions concerning foreign investment protections and dispute resolution mechanisms, alongside a comprehensive understanding of the Alabama Securities Act's registration, disclosure, and anti-fraud requirements. This approach prioritizes understanding how the AMPTA framework might interact with, or potentially create exceptions to, Alabama's securities regulations. Specifically, it requires identifying if the AMPTA offers any carve-outs or specific procedures for foreign investors that would alter the standard registration or disclosure obligations under Alabama law. If the AMPTA mandates specific notification or consultation processes with state authorities before investment, these must be followed diligently. This approach ensures that all actions taken are compliant with both the international agreement and state law, safeguarding the firm and its clients. Incorrect approaches analysis. One incorrect approach would be to solely rely on the AMPTA provisions without considering the Alabama Securities Act. This failure to integrate domestic regulatory requirements could lead to violations of state law, such as offering unregistered securities or failing to provide required disclosures to Alabama investors, resulting in significant penalties and legal challenges. Another incorrect approach would be to assume that the AMPTA automatically supersedes all Alabama securities regulations without explicit confirmation or specific provisions within the AMPTA that grant such authority. This assumption overlooks the principle that international agreements often operate within the existing domestic legal framework, unless otherwise specified, and that state-level investor protection laws remain paramount unless directly and unequivocally preempted. A third incorrect approach would be to proceed with the investment based on a superficial understanding of the AMPTA, without seeking legal counsel or conducting due diligence on the specific implications for Alabama investors. This could result in inadvertent violations of disclosure requirements or anti-fraud provisions of the Alabama Securities Act, exposing the firm to liability. Professional reasoning. Professionals facing such situations should adopt a systematic approach. First, identify all relevant legal and regulatory frameworks, both international and domestic. Second, meticulously analyze the interplay between these frameworks, paying close attention to any potential conflicts or specific provisions that modify standard obligations. Third, consult with legal experts specializing in both international investment law and Alabama securities law to ensure a comprehensive understanding of compliance requirements. Fourth, document all analyses, consultations, and decisions made to demonstrate due diligence and adherence to regulatory standards. Question 6. The review process indicates that a foreign-owned company operating in Alabama, which has invested significant capital in a renewable energy project, alleges that recent regulatory changes enacted by the Alabama Department of Environmental Management have substantially diminished the value and profitability of its investment, potentially constituting an expropriatory act or a breach of fair and equitable treatment under an applicable bilateral investment treaty, BIT. Which of the following approaches best addresses this situation? Option A. Conclude that since the regulatory changes were enacted by a state agency exercising its legitimate domestic authority, they cannot constitute a violation of any international treaty obligations, and therefore the company's claims should be dismissed without further investigation. Option B. Conduct a precise review of the specific BIT between the United States and the company's home country, focusing on the definitions of investment and investor, and the scope of protections such as fair and equitable treatment and prohibition of indirect expropriation, to determine if the company's project qualifies as a protected investment, and if the regulatory changes violate any treaty obligations. Option C. Prioritize the assertion of Alabama's sovereign right to regulate its environmental affairs without regard to any potential international treaty implications, as domestic regulatory power supersedes all international investment commitments. Option D. Assume that any foreign entity making a substantial capital investment in Alabama is automatically covered by all BITs to which the United States is a party, and therefore the company's allegations must be addressed under general international investment law principles. The correct answer is B. Conduct a precise review of the specific BIT between the United States and the company's home country, focusing on the definitions of investment and investor, and the scope of protections such as fair and equitable treatment and prohibition of indirect expropriation, to determine if the company's project qualifies as a protected investment, and if the regulatory changes violate any treaty obligations. Explanation. The review process indicates a scenario that is professionally challenging due to the inherent complexities of international investment law and the specific obligations arising from bilateral investment treaties, BIT, to which Alabama is a party. Navigating these treaties requires a nuanced understanding of their provisions, the scope of protected investments, and the procedural mechanisms for dispute resolution. Careful judgment is required to ensure that any action taken by the state of Alabama aligns with its treaty commitments and avoids potential international disputes. The correct approach involves a thorough and precise interpretation of the relevant BIT's definition of investment and investor, alongside an examination of the specific protections afforded under that treaty. This requires consulting the text of the BIT itself, any accompanying protocols or understandings, and potentially relevant jurisprudence from international investment tribunals that have interpreted similar provisions. The justification for this approach lies in the principle of treaty interpretation, which mandates that states act in good faith and adhere to the plain meaning of treaty text, supplemented by established methods of interpretation. Alabama's obligations under a BIT are binding international law, and failure to adhere to these obligations can lead to formal dispute resolution proceedings initiated by the foreign investor. Therefore, a meticulous review of the treaty's specific terms is paramount to determine if the foreign entity's activities constitute a protected investment, and if the alleged actions by the state violate any treaty provisions. An incorrect approach would be to broadly assume that any foreign entity operating within Alabama is automatically covered by a BIT, without a specific analysis of the treaty's definitions. This fails to acknowledge that BITs often have specific criteria for what constitutes a protected investment, e.g., requiring a certain duration, commitment of capital, or expectation of profit, and an investor, e.g., nationality or incorporation requirements. This oversight could lead to misinterpreting the scope of Alabama's obligations and potentially facing claims for breaches of treaty provision that do not apply to the specific situation. Another incorrect approach would be to dismiss the foreign entities concerned solely based on the fact that the alleged actions were taken by a state agency acting within its domestic regulatory authority. While domestic regulatory authority is generally respected, BITs often contain provisions that limit a state's ability to take actions that impair or expropriate protected investments without due process or fair compensation. Ignoring the potential for a BIT claim simply because the action was taken domestically is a failure to recognize the extraterritorial reach of international investment law. A further incorrect approach would be to rely solely on general principles of international law regarding state sovereignty, without first ascertaining the specific commitments Alabama has undertaken through its BITs. While state sovereignty is a fundamental principle, it can be limited by treaty obligations voluntarily entered into. A BIT represents a specific waiver or modification of absolute sovereignty in relation to covered investments. The professional reasoning process for professionals in such situations should begin with identifying the potential applicability of international law, specifically any BITs to which the relevant jurisdiction, Alabama, is a party. This should be followed by a detailed examination of the specific BIT's provisions, including definitions of investment and investor, and the substantive protections offered. Concurrently, the factual circumstances of the foreign entity's operations and the state's actions must be carefully assessed against these treaty provisions. If there is a potential conflict or ambiguity, seeking expert legal advice on international investment law and treaty interpretation is crucial. The ultimate goal is to ensure compliance with international obligations while upholding domestic legal and regulatory frameworks. Question 7. Examination of the data shows that an Alabama-based client is considering a significant investment in a renewable energy project located in a neighboring state that is also a signatory to the hypothetical Southeastern Energy Investment Accord, SEA. The SEA is a regional agreement designed to facilitate cross-border energy investments among participating states, outlining specific investor protections and reporting requirements. As an investment advisor licensed in Alabama, what is the most prudent course of action to ensure full compliance and protect the client's interests? Option A. Apply general knowledge of regional investment agreements to the SEA, assuming its structure and requirements are similar to other regional pacts without consulting the specific text of the SEA itself. Option B. Thoroughly review the Southeastern Energy Investment Accord, SEA, to understand its specific provisions regarding investor rights, disclosure obligations, and reporting requirements, and then cross-reference these with Alabama's Securities Act and any applicable federal regulations to ensure comprehensive compliance. Option C. Advise the client to prioritize the potential economic returns of the investment and to address any regulatory concerns that may arise after the investment is finalized. Option D. Proceed with the investment based solely on Alabama's Securities Act, assuming that the SEA provisions are either redundant or less stringent than state-level regulations. The correct answer is B. Thoroughly review the Southeastern Energy Investment Accord, SEA, to understand its specific provisions regarding investor rights, disclosure obligations, and reporting requirements, and then cross-reference these with Alabama's Securities Act and any applicable federal regulations to ensure comprehensive compliance. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an investment advisor to navigate the complexities of regional investment agreements that may have overlapping or conflicting provisions, particularly when advising a client on cross-border investments within a specific region. The advisor must ensure compliance with the applicable regulatory framework of Alabama, while also understanding the implications of any regional agreements that might impact the investment structure, reporting, or investor protections. Misinterpreting or ignoring these agreements can lead to regulatory breaches, financial penalties, and reputational damage for both the advisor and the client. Correct approach analysis. The best professional practice involves a thorough review of the specific regional investment agreement applicable to the proposed investment, alongside Alabama's domestic investment laws. This approach correctly prioritizes understanding the precise terms and conditions of the regional agreement, such as those potentially established under the Southern States Economic Development Compact, a hypothetical regional agreement for this context, and how they interact with Alabama's Securities Act and any relevant federal regulations. The advisor must identify any specific disclosure requirements, investor rights, or operational mandates stipulated by the regional agreement that go beyond or modify Alabama's standard requirements. This ensures full compliance and provides the client with accurate, context-specific advice, thereby upholding fiduciary duties and regulatory obligations. Incorrect approaches analysis. One incorrect approach is to solely rely on Alabama's domestic investment laws without considering the regional agreement. This fails to acknowledge that regional agreements can introduce additional layers of regulation or specific carve-outs that are binding within the participating states. Ignoring the regional agreement could lead to non-compliance with its provisions, potentially resulting in sanctions or invalidating aspects of the investment from the perspective of the regional framework. Another incorrect approach is to assume that all regional investment agreements operate identically and to apply general knowledge of such agreements without consulting the specific text of the relevant pact. This overlooks the unique provisions and nuances of each agreement, which can vary significantly in scope, enforcement mechanisms, and investor protections. Such an assumption risks misinterpreting the client's obligations and rights. A further incorrect approach is to prioritize the perceived economic benefits of the investment over strict adherence to both state and regional regulatory requirements. While economic viability is a key consideration for the client, it does not supersede legal and regulatory obligations. An advisor's duty is to ensure the investment is structured and executed in a compliant manner, regardless of potential economic advantages that might be jeopardized by noncompliance. Professional reasoning. Professionals should adopt a systematic approach to advising on cross-border investments within a region. This involves 1. Identifying the specific regional investment agreement that govern the proposed transaction. 2. Conducting a detailed comparative analysis of the regional agreement's provisions against the domestic investment laws of the relevant state, in this case, Alabama. 3. Consulting legal counsel specializing in regional and state-specific investment law if ambiguities or conflicts arise. 4. Clearly documenting the research, analysis, and advice provided to the client, including any identified risks and compliance strategies. This structured process ensures thoroughness, accuracy, and adherence to all applicable legal and ethical standards. Question 8. Upon reviewing the potential for a new manufacturing facility in Alabama that plans to utilize a process with significant wastewater discharge, Alabama's Environmental Agency is considering implementing stricter wastewater treatment standards than currently exist. An investor from a country with which the United States has an investment chapter within a free trade agreement is considering a substantial investment in this facility. What is the most prudent course of action for Alabama to ensure its environmental protection goals are met while minimizing the risk of an international investment dispute? Option A. Conduct a thorough legal analysis of the relevant FTA's investment chapter, focusing on environmental exceptions and dispute settlement provisions, to determine if the proposed stricter standards are permissible and how to implement them in a compliant manner. Option B. Proceed with implementing the stricter wastewater treatment standards without extensive review of the FTA, relying on Alabama's inherent sovereign right to regulate environmental matters. Option C. Immediately inform the investor that the stricter standards will be applied and offer concessions to mitigate their impact, without a full assessment of the FTA's implications. Option D. Implement the stricter standards and inform the investor that they must comply, without considering whether these standards are discriminatory compared to those applied to domestic industries. The correct answer is A. Conduct a thorough legal analysis of the relevant FTA's investment chapter, focusing on environmental exceptions and dispute settlement provisions, to determine if the proposed stricter standards are permissible and how to implement them in a compliant manner. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent complexities of interpreting and applying investment provisions within a free trade agreement, FTA. in the context of Alabama's specific economic interests and regulatory environment. The challenge lies in balancing the investor's rights and expectations under the FTA with Alabama's sovereign right to regulate in the public interest, particularly concerning environmental standards. Careful judgment is required to navigate potential disputes and ensure compliance with both international obligations and state-level policy objectives. Correct approach analysis. The best professional approach involves a thorough review of the specific investment chapter of the relevant FTA, paying close attention to provisions related to environmental protection and the scope of investor-state dispute settlement ISTs. This approach necessitates understanding the exceptions and carve-outs within the FTA that allow states to maintain or implement environmental measures, provided they are non-discriminatory and do not constitute disguised restrictions on trade. It also requires assessing whether the proposed regulations in Alabama align with these exceptions and whether they are implemented in a transparent and procedurally fair manner. This aligns with the principle of respecting international commitments while upholding domestic regulatory authority for legitimate public policy goals. Incorrect approaches analysis. One incorrect approach would be to disregard the investment chapter of the FTA entirely, assuming Alabama's sovereign right to regulate is absolute and unfettered by international agreements. This fails to acknowledge the binding nature of FTAs and the potential for ISTs claims if investors believe their rights under the agreement have been violated. Such an approach risks significant legal and financial repercussions for the state. Another incorrect approach would be to immediately concede to the investor's demands without a comprehensive legal analysis of the FTA's provisions. This approach prioritizes avoiding conflict over upholding legitimate state interests and regulatory standards. It undermines the state's ability to implement policies designed to protect its environment and citizens, potentially setting a precedent for future challenges. A further incorrect approach would be to implement the environmental regulations without considering their potential impact on the investor's existing operations or their compatibility with the FTA's non-discrimination clauses. This could lead to claims of unfair treatment or expropriation, even if the regulations are well-intentioned, if they disproportionately affect foreign investors compared to domestic ones. Professional reasoning. Professionals facing such a situation should adopt a systematic approach. First, they must identify the specific FTA and the relevant investment chapter. Second, they need to conduct a detailed legal analysis of the chapter's provisions, including definitions, obligations, exceptions, and dispute settlement mechanisms. Third, they should assess the proposed state regulations against these provisions, considering both the substantive requirements and procedural fairness. Fourth, they should consult with legal counsel specializing in international investment law and trade agreements. Finally, they should engage in transparent communication with stakeholders, including the investor, to seek mutually agreeable solutions where possible, while firmly defending the state's legitimate regulatory space. Question 9. When evaluating a proposed international investment into Alabama, and an investor cites informal assurances from a former executive of the Alabama-based company as the basis for their understanding of the terms, what is the most prudent course of action for the Alabama company to ensure compliance with Alabama's regulatory framework and uphold principles of transparency? Option A. Immediately seek to create retrospective documentation to support the investor's claims, aligning with the informal assurances provided by the former executive. Option B. Advise the investor that informal assurances are not legally binding and disregard their concerns, proceeding with the investment as initially planned without further review. Option C. Conduct a comprehensive review of all applicable Alabama statutes and regulations governing international investments and require formal documentation and approvals before proceeding. Option D. Proceed with the investment based on the informal assurances, assuming the former executive's statements were accurate and binding. The correct answer is C. Conduct a comprehensive review of all applicable Alabama statutes and regulations governing international investments and require formal documentation and approvals before proceeding. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a conflict between a foreign investor's perceived entitlement based on prior informal assurances and the strict application of Alabama's regulatory framework governing international investments. The investor's reliance on these assurances, even if not legally binding, creates a potential for dispute and reputational damage for the Alabama entity. Navigating this requires a delicate balance between upholding regulatory integrity and managing stakeholder relationships. Correct approach analysis. The best professional approach involves a thorough review of all applicable Alabama statutes and regulations pertaining to foreign investment, specifically examining provisions related to disclosure, licensing, and any requirements for formal agreements or approvals. This approach prioritizes adherence to the established legal framework, ensuring that any investment proceeds are compliant and transparent. It acknowledges that informal assurances, while potentially influential in business dealings, do not supersede formal legal obligations. This aligns with the principles of transparency and good governance mandated by Alabama's regulatory environment, which expects all parties to operate within the defined legal parameters. Incorrect approaches analysis. One incorrect approach would be to proceed with the investment based solely on the informal assurances provided by the former executive. This fails to acknowledge the transparency requirements inherent in Alabama's investment laws, which necessitate formal documentation and regulatory compliance. It risks operating outside the legal framework, potentially leading to penalties, rescission of the investment, and damage to the reputation of both the investor and the Alabama entity. Another incorrect approach would be to dismiss the investor's concerns entirely without a formal review of the situation. This demonstrates a lack of professional diligence and could be perceived as a failure to act in good faith, potentially exacerbating the dispute and leading to legal challenges. Finally, attempting to retroactively create documentation to justify the investment after the fact would be a serious ethical and regulatory breach, undermining the principle of transparency and potentially constituting misrepresentation. Professional reasoning. Professionals should adopt a systematic approach when faced with such situations. First, identify the core issue, a potential discrepancy between informal expectations and formal regulatory requirements. Second, conduct a comprehensive review of all relevant laws and regulations within the specified jurisdiction, Alabama. Third, gather all pertinent documentation, including any written communications, even informal ones, related to the investment. Fourth, consult with legal counsel specializing in Alabama investment law to interpret the regulatory landscape and advise on the proper course of action. Fifth, communicate transparently with the investor, explaining the regulatory requirements and the steps being taken to ensure compliance, while managing expectations regarding the validity of informal assurances. Question 10. The analysis reveals that an international firm, operating through a newly established shell corporation in a jurisdiction known for lax financial oversight, proposes to invest $50 million in annual revenue into a critical telecommunications infrastructure project within Alabama. The firm's country of origin presents a moderate risk score of 6 out of 10. The ownership structure is complex score of 8 out of 10, and the sector is deemed highly critical score of 9 out of 10. The weighted risk score is calculated using a formula where the investor's country of origin risk, ownership structure complexity, and sector criticality are weighted at 0, 4, 0, 3, and 0, 3 respectively. If the established threshold for heightened national security review is a weighted risk score exceeding 7, 0, what is the most appropriate course of action for the Alabama authorities? Option A. Approve the investment immediately due to the significant projected annual revenue of $50 million, as economic benefits are paramount. Option B. Recommend a thorough national security review by the Alabama Attorney General's office and relevant federal bodies, while simultaneously exploring mitigation strategies with the investor, given the calculated weighted risk score. Option C. Reject the investment outright based on the investor's country of origin and the complex ownership structure, without further investigation. Option D. Approve the investment after a cursory review that only considers the critical nature of the telecommunications sector, overlooking other risk factors. The correct answer is B. Recommend a thorough national security review by the Alabama Attorney General's office and relevant federal bodies, while simultaneously exploring mitigation strategies with the investor, given the calculated weighted risk score. Explanation. The analysis reveals a complex scenario involving potential foreign investment in a critical infrastructure sector within Alabama, triggering national security considerations. The situation is professionally challenging because it requires balancing economic development goals with the imperative to protect national security interests, as defined by Alabama law and federal guidelines incorporated by reference. The investor's proposed structure, involving a shell corporation in a jurisdiction with weak regulatory oversight, raises red flags that necessitate a thorough review beyond standard due diligence. Careful judgment is required to identify potential risks and apply the appropriate legal and regulatory frameworks without unduly hindering legitimate investment. The correct approach involves a multifaceted review that prioritizes a comprehensive assessment of the investor's ultimate beneficial ownership and the strategic implications of the investment for Alabama's critical infrastructure. This includes engaging with relevant state and federal agencies to understand the specific national security concerns associated with the targeted sector. The calculation of the potential economic benefit, represented by the projected annual revenue of $50 million, must be weighed against the calculated risk score. The risk score is determined by a weighted average of 3 factors. 1. The investor's country of origin risk, assigned a weight of 0. 2. The complexity of the ownership structure, assigned a weight of 0. 3. The sector's criticality, assigned a weight of 0. 3. The investor's country of origin has a moderate risk score of 6 out of 10. The ownership structure is complex score of 8 out of 10. And the sector is highly critical score of 9 out of 10. The weighted risk score is calculated as \0, 4 times 6 plus 0, 3 times 8 plus 0, 3 times 9 equals 2, 4 plus 2, 4 plus 2, 7 equals 7. 5 given this weighted risk score of 7. 5, which exceeds the established threshold of 7. 0 for heightened scrutiny. The appropriate action is to recommend a thorough national security review by the Alabama Attorney General's office and relevant federal bodies, while simultaneously exploring mitigation strategies with the investor. This approach aligns with the principles of safeguarding state interests while remaining open to responsible investment. An incorrect approach would be to solely focus on the projected economic benefit of $50 million in annual revenue and approve the investment without further scrutiny. This fails to acknowledge the explicit provisions within Alabama law that mandate consideration of national security implications for investments in critical infrastructure, irrespective of their economic upside. The regulatory framework requires a proactive assessment of risks, not merely a passive acceptance of potential gains. Another incorrect approach would be to reject the investment outright based solely on the investor's country of origin and the complexity of the ownership structure, without conducting a detailed risk assessment or engaging in dialogue with the investor. This demonstrates a failure to apply the weighted risk calculation and a lack of due diligence in understanding the specific nature of the investment and potential mitigation measures. It also risks violating principles of fair treatment for foreign investors. A further incorrect approach would be to approve the investment after a superficial review that only considers the sector's criticality and overlooks the investor's risk profile and ownership structure. This would lead to an incomplete risk assessment, failing to utilize the full scope of the regulatory framework designed to identify and address multifaceted threats. The professional decision-making process for similar situations should involve 1. Identifying all applicable legal and regulatory frameworks, including state and federal laws pertaining to foreign investment and national security. 2. Conducting a comprehensive due diligence process that assesses not only financial viability but also potential risks, including national security, public health, and environmental concerns. 3. Applying quantitative and qualitative risk assessment tools, such as weighted scoring models, to evaluate the identified risks. 4. Engaging with relevant government agencies and stakeholders to gather information and seek expert advice. 5. Communicating transparently with investors regarding concerns and potential mitigation strategies. 6. Making a decision that is grounded in legal compliance, ethical considerations, and the best interests of the state. Question 11. Comparative studies suggest that in the context of an ongoing investor-state dispute settlement (ISDS) proceeding initiated by an Alabama-based company against a foreign state under an applicable investment treaty, an investment advisor has a professional obligation to guide their client. Considering Alabama's regulatory framework for international investments and the principles of ISDS, which of the following actions best represent the advisor's ethical and legal responsibility? Option A. Encourage the client to initiate parallel public relations campaigns to pressure the host state, potentially involving unsubstantiated claims about the host state's investment practices. Option B. Advise the client on the legal merits of their ISTS claim and the potential outcomes, ensuring all communications regarding the dispute are channeled through the client's legal counsel and adhere strictly to the procedural rules of the arbitration, while also ensuring full compliance with Alabama's disclosure requirements for investment advice. Option C. Recommend that the client cease all communication with the arbitral tribunal and the host state's legal team until a resolution is reached, regardless of any procedural requirements or requests for information. Option D. Directly contact the opposing state's representatives to explore a potential settlement outside the formal arbitration process, without the explicit instruction or involvement of the client's legal counsel. The correct answer is B. Advise the client on the legal merits of their ISTS claim and the potential outcomes, ensuring all communications regarding the dispute are channeled through the client's legal counsel and adhere strictly to the procedural rules of the arbitration, while also ensuring full compliance with Alabama's disclosure requirements for investment advice. Explanation: this scenario is professionally challenging because it requires navigating the complex intersection of international investment law, specifically investor-state dispute settlement (ISTS), under Alabama's regulatory framework for international investments, and the ethical obligations of an investment advisor. The advisor must balance their client's potential financial interests with the integrity of the ISTS process and adherence to Alabama's specific investment regulations. Careful judgment is required to avoid actions that could be construed as influencing or interfering with a pending dispute, which could have severe legal and reputational consequences for both the client and the advisor. The correct approach involves advising the client on the legal and strategic implications of their investment and the potential ISTS claim, while strictly adhering to Alabama's regulations governing investment advice and disclosure. This includes ensuring all advice is based on objective analysis of the relevant investment treaty and Alabama's investment laws, and that any communication with parties involved in the ISTS process is conducted through appropriate legal channels, respecting the procedural rules of the arbitration. This approach upholds the advisor's fiduciary duty to the client by providing informed counsel, while simultaneously respecting the integrity of the ISTS mechanism and Alabama's regulatory oversight. An incorrect approach would be to directly contact the opposing party or the arbitral tribunal to lobby for a favorable outcome. This is ethically unacceptable, as it constitutes an attempt to improperly influence the dispute resolution process, potentially violating principles of fairness and due process inherent in ISTS. Such an action could also contravene Alabama's regulations concerning professional conduct for investment advisors, which typically prohibit deceptive or manipulative practices. Another incorrect approach is to advise the client to withhold relevant information from their legal counsel or the arbitral tribunal. This undermines the principle of good faith in legal proceedings and could lead to sanctions or adverse findings against the client. It also violates the advisor's ethical duty to promote honest and transparent dealings. A further incorrect approach is to suggest the client engage in actions that could be perceived as retaliatory or coercive towards the host state outside of the formal ISTS proceedings. This could escalate the dispute in an unprofessional manner and potentially create new legal liabilities for the client, while also demonstrating a disregard for the established dispute resolution framework under Alabama's international investment law. Professionals should employ a decision-making framework that prioritizes legal compliance, ethical conduct, and client best interests within the established legal and regulatory boundaries. This involves thorough research into the specific investment treaty and Alabama's relevant laws, consultation with legal experts specializing in international arbitration and investment law, and maintaining clear, documented communication with the client about risks and options. The focus should always be on facilitating a fair and lawful resolution, rather than attempting to circumvent or improperly influence the process. Question 12. The investigation demonstrates that a foreign investor, operating under an investment agreement with the state of Alabama, alleges breaches of treaty obligations related to its infrastructure project. The investment agreement contains a clause referencing dispute resolution mechanisms, but its specific application to international arbitration is ambiguous. The investor is considering initiating arbitration proceedings. Which of the following approaches best navigates the jurisdictional requirements for resolving this international investment dispute involving Alabama? Option A. File a lawsuit exclusively in Alabama state courts to resolve the dispute, disregarding any potential international arbitration clauses in the investment agreement. Option B. Thoroughly review the investment agreement and any applicable bilateral or multilateral investment treaties to which the United States is a party and which extend to subfederal entities like Alabama, to identify explicit consent to arbitration and the designated forum, e.g., ICSID or UNCITRAL, and then proceed accordingly. Option C. Immediately initiate arbitration proceedings under the auspices of ICSID, assuming that the nature of the dispute automatically confers jurisdiction. Option D. Commence arbitration proceedings under the UNCITRAL rules, as these are commonly used for international commercial disputes, without first confirming specific treaty or agreement provisions for their application. The correct answer is B. Thoroughly review the investment agreement and any applicable bilateral or multilateral investment treaties to which the United States is a party and which extend to subfederal entities like Alabama, to identify explicit consent to arbitration and the designated forum, e.g., ICSID or UNCITRAL, and then proceed accordingly. Explanation. The investigation demonstrates a complex scenario involving an international investment dispute where a foreign investor, operating under an investment agreement with the state of Alabama, alleges breaches of treaty obligations. The core challenge lies in determining the appropriate forum for dispute resolution, balancing the investor's rights with Alabama's sovereign interests and its adherence to international investment law principles as they pertain to U.S. states. This requires a nuanced understanding of available arbitration mechanisms and their jurisdictional prerequisites. The most professionally sound approach involves a thorough examination of the investment agreement and any applicable bilateral investment treaties, BIT, or multilateral agreements to which the United States is a party and which extend to subfederal entities like Alabama. This approach prioritizes identifying a dispute resolution clause that explicitly grants jurisdiction to a recognized international arbitration institution. Specifically, it would involve assessing whether the agreement or treaty designates ICSID, International Center for Settlement of Investment Disputes, or UNCITRAL, United Nations Commission on International Trade Law Arbitration, and whether the conditions for invoking such arbitration, e.g., consent, waiting periods, specific types of disputes, have been met. This is correct because it directly addresses the legal basis for international arbitration, ensuring that any chosen forum has proper jurisdiction, and that the process aligns with established international norms and the specific commitments made by the United States, and by extension, Alabama. Adherence to these contractual and treaty provisions is paramount for the legitimacy and enforceability of any arbitral award, an approach that immediately seeks to initiate arbitration under ICSID without first verifying if the investment agreement or a relevant treaty grants Alabama's consent to ICSID jurisdiction would be professionally flawed. While ICSID is a primary forum for investment disputes, its jurisdiction is based on consent, which must be clearly established. Without such consent, an ICSID proceeding would be invalid from the outset, wasting resources and potentially prejudicing the investor's claim. Similarly, initiating arbitration under UNCITRAL rules without confirming that the investment agreement or a treaty provides for such a mechanism, or that both parties have agreed to its use for this specific dispute, would be incorrect. UNCITRAL arbitration is often chosen by parties, but it is not automatically available unless stipulated. Proceeding without this confirmation risks a jurisdictional challenge and the invalidation of the arbitral process. Finally, an approach that bypasses international arbitration altogether and attempts to resolve the dispute solely through Alabama state courts, without considering the international investment agreement's dispute resolution provisions, would be professionally unsound. While state courts have jurisdiction over domestic matters, they may not be the appropriate forum for disputes involving alleged breaches of international investment obligations, especially if the agreement mandates international arbitration. This could lead to the investor seeking parallel proceedings or challenging the jurisdiction of the state court based on the international agreement. The professional decision-making process in such situations should begin with a meticulous review of all relevant legal instruments, the investment agreement, any applicable BITs or multilateral treaties, and domestic laws of Alabama and the United States that govern international investment and arbitration. This foundational step ensures that the chosen dispute resolution path is legally sound and has the highest probability of achieving a valid and enforceable outcome. Question 13. Analysis of a client's investment profile in Alabama reveals a stated desire for aggressive, high-growth international investments. The client, a retired individual with a moderate but stable income from pensions and Social Security, has expressed a strong interest in emerging market equities and complex international derivatives, believing these offer the best path to significant capital appreciation. The advisor has conducted a preliminary risk assessment which indicates the client has a moderate capacity for risk, but the client's stated desire for explosive growth seems to exceed this assessed capacity. What is the most appropriate course of action for the investment advisor in Alabama? Option A. Conduct a detailed, documented suitability analysis that thoroughly assesses the client's financial situation, investment objectives, and risk tolerance, and then recommend international investments that demonstrably align with these factors, clearly explaining all associated risks. Option B. Proceed with investing a significant portion of the client's portfolio in the emerging market equities and international derivatives the client has identified, based on their explicit request for high growth, assuming the client understands the inherent risks. Option C. Recommend a portfolio heavily weighted towards domestic blue-chip stocks and bonds, explaining that these offer more stable growth and are less susceptible to the volatility of international markets, despite the client's stated preference. Option D. Invest in a highly speculative, illiquid international real estate fund that has shown recent high returns, without extensive explanation of the fund's structure or exit strategies, as this aligns with the client's desire for aggressive growth. The correct answer is A. Conduct a detailed, documented suitability analysis that thoroughly assesses the client's financial situation, investment objectives, and risk tolerance, and then recommend international investments that demonstrably align with these factors, clearly explaining all associated risks. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an investment advisor to balance the client's stated desire for aggressive growth with the advisor's fiduciary duty to ensure investments are suitable and align with the client's risk tolerance and financial objectives, especially when dealing with international investments which can carry unique risks. The advisor must navigate potential conflicts of interest and ensure compliance with Alabama's specific regulatory framework for investment advice. Correct approach analysis. The best professional approach involves a thorough, documented assessment of the client's financial situation, investment objectives, and risk tolerance, followed by a recommendation of international investments that demonstrably align with these factors. This approach prioritizes the client's best interests and adheres to the substantive standards of protection mandated by Alabama law, which requires advisors to act with prudence, diligence, and in good faith, ensuring that recommendations are suitable and not based on the advisor's personal gain or speculative opportunities that exceed the client's capacity. This includes understanding the specific risks associated with emerging markets or complex international instruments. Incorrect approach is analysis. Recommending a high-risk international fund solely based on the client's verbal expression of wanting explosive growth without a comprehensive suitability assessment is a failure to meet the substantive standards of protection. This approach neglects the advisor's duty to understand the client's true risk capacity and financial goals, potentially exposing the client to undue losses. Suggesting a diversified portfolio of domestic, lower-risk investments despite the client's explicit request for international exposure, while seemingly cautious, fails to adequately address the client's stated objectives and could be seen as paternalistic or a missed opportunity if suitable international options exist. This approach may not fully honor the client's informed preferences within the bounds of suitability. Investing in a complex, a liquid international private equity fund without fully explaining the substantial risks, lack of liquidity, and potential for total loss, even if the client expresses interest in high returns, violates the duty of care and transparency. This approach prioritizes the potential for high returns over the client's understanding and capacity to absorb significant risk and potential illiquidity. Professional reasoning. Professionals should employ a structured decision-making process that begins with a deep understanding of the client's profile, including their financial situation, investment objectives, and risk tolerance. This understanding must be documented. Next, the advisor must identify investment options that align with this profile, considering all relevant risks and potential rewards. For international investments, this includes understanding geopolitical risks, currency fluctuations, and regulatory differences. The advisor must then clearly communicate these risks and potential benefits to the client, ensuring informed consent. Finally, the advisor must continuously monitor the investments and the client's situation to ensure ongoing suitability, always prioritizing the client's best interests as mandated by Alabama's regulatory framework. Question 14. Consider a scenario where a foreign investor in Alabama, operating a manufacturing facility, receives an unexpected and severe operational shutdown order from the Alabama Department of Environmental Quality, ADEQ, due to alleged minor, previously unaddressed, and non-imminent environmental infractions. The investor claims they were not provided adequate notice or a meaningful opportunity to rectify the issues before the shutdown, and that similar infractions by domestic companies have resulted in less stringent enforcement. The investor argues this constitutes a breach of the Fair and Equitable Treatment (FET) standard under the relevant international investment agreement. Which of the following approaches best addresses the investor's claim? Option A. Focus solely on whether the ADEQ enforcement actions were consistent with Alabama's domestic environmental statutes, and if they were, dismiss the FET claim as irrelevant. Option B. Determine that since the ADEQ actions were based on environmental protection, a legitimate state interest, the investor's claim of unfair treatment is invalid, as the state's regulatory power supersedes international investment obligations in such cases. Option C. Conclude that the ADEQ acted within its sovereign authority to enforce environmental laws, and therefore, no breach of FET occurred, regardless of the investor's claims about notice or procedural fairness. Option D. Analyze the ADEQ actions by examining the specific terms of the investment agreement, Alabama's environmental regulations, and relevant international arbitral jurisprudence on FET, focusing on whether the investor's legitimate expectations were violated through a lack of transparency, due process, or arbitrary enforcement. The correct answer is D. Analyze the ADEQ actions by examining the specific terms of the investment agreement, Alabama's environmental regulations, and relevant international arbitral jurisprudence on FET, focusing on whether the investor's legitimate expectations were violated through a lack of transparency, due process, or arbitrary enforcement. Explanation. Scenario analysis. This scenario presents a professional challenge because it involves a foreign investor's perception of unfair treatment by a host state, which directly implicates the Fair and Equitable Treatment (FET) standard under international investment law, specifically as it might be interpreted within Alabama's regulatory context concerning foreign investment. The challenge lies in discerning whether the actions taken by the Alabama Department of Environmental Quality, ADEQ, constitute a breach of FET, which requires a nuanced understanding of what constitutes fair and equitable beyond mere legality. Professionals must navigate the tension between a state's sovereign right to regulate for public welfare, environmental protection, and its international obligations to provide a stable and predictable investment climate. The ambiguity of the FET standard itself, which is not a static concept, but evolves through treaty interpretation and arbitral jurisprudence, adds to the complexity. Correct approach analysis. The best professional approach involves a thorough review of the specific investment agreement or treaty governing the foreign investment, alongside an analysis of Alabama's environmental regulations and the ADEQ actions in light of established international jurisprudence on FET. This approach recognizes that FET encompasses not only adherence to domestic law, but also the protection of legitimate expectations, due process, and the absence of arbitrariness or discrimination. It requires examining whether the ADEQ actions were transparent, non-discriminatory, based on objective criteria, and whether the investor was afforded an opportunity to be heard and present its case before a final decision was made. The absence of a clear, pre-existing, and consistently applied regulatory standard that the investor violated, coupled with a lack of procedural fairness, would strongly suggest a breach of FET. Incorrect approaches analysis. One incorrect approach would be to solely focus on whether the ADEQ actions were lawful under Alabama state law. While domestic legality is a necessary condition, it is not sufficient to satisfy FET. International law imposes obligations that can extend beyond domestic legal requirements, particularly concerning the protection of foreign investments. If the ADIC actions, though technically within its statutory powers, were arbitrary, discriminatory, lacked transparency, or deprived the investor of due process, they could still constitute a breach of FET, even if no specific Alabama statute was violated. Another incorrect approach would be to assume that any regulatory action taken by a state agency, regardless of its impact or the process followed, is permissible as an exercise of sovereign regulatory power. This overlooks the international commitment to provide fair and equitable treatment to foreign investors. The sovereign right to regulate is not absolute and must be exercised in a manner that respects the legitimate expectations of investors and adheres to international standards of due process and non-arbitrariness. A further incorrect approach would be to dismiss the investor's concerns simply because the regulatory action was intended to protect public health and the environment. While environmental protection is a legitimate state interest, the means by which it is pursued must be fair and equitable. A disproportionate or procedurally flawed regulatory action, even for a laudable public purpose, can still violate FET if it is not implemented in a reasonable, transparent, and non-discriminatory manner. Professional reasoning. Professionals should adopt a framework that begins with identifying the applicable international investment treaty or agreement. This is followed by a detailed examination of the host states, Alabama's, domestic laws and regulations relevant to the investment. Crucially, the analysis must then assess the host state's actions against the established international jurisprudence concerning the FET standard, considering elements such as transparency, due process, legitimate expectations, and the absence of arbitrariness and discrimination. This comprehensive approach ensures that both domestic legal compliance and international treaty obligations are adequately addressed, leading to a sound professional judgment. Question 15. During the evaluation of a potential international investment opportunity in a developing nation for an Alabama-based client, an investment advisor must ensure the investment offers full protection and security, FPS, as understood within the Alabama regulatory framework. The client is eager for high returns, but also expresses concern about the safety of their capital. The advisor has identified several potential strategies to enhance security. Which of the following strategies best embodies the principles of FPS in this context? Option A. Relying on the assurances of local partners in the target country regarding the safety and security of foreign investments, without independent verification or further risk assessment. Option B. Prioritizing the investment with the highest projected rate of return, assuming that strong performance inherently provides a form of security by outperforming potential losses. Option C. Conducting a thorough due diligence investigation into the political, economic, and legal stability of the target country, identifying specific threats to foreign investments, and implementing tailored risk mitigation measures such as political risk insurance and diversification, while clearly communicating all residual risks to the client. Option D. Structuring the investment solely through offshore entities to shield it from Alabama regulations, thereby creating a de facto form of security through regulatory arbitrage. The correct answer is C. Conducting a thorough due diligence investigation into the political, economic, and legal stability of the target country, identifying specific threats to foreign investments, and implementing tailored risk mitigation measures such as political risk insurance and diversification, while clearly communicating all residual risks to the client. Explanation. This scenario is professionally challenging because it requires balancing a client's desire for aggressive investment growth with the fundamental duty to protect their capital, especially in a volatile international market. The core tension lies in interpreting full protection and security, FPS, within the context of Alabama's regulatory framework for international investments, which emphasizes safeguarding client assets against foreseeable risks. The best approach involves a comprehensive risk assessment and clear communication of potential downsides. This entails thoroughly investigating the political, economic, and legal stability of the target country, identifying specific threats to foreign investments, such as expropriation, currency devaluation, or regulatory changes, and then structuring the investment to mitigate these identified risks. This includes exploring options like sovereign guarantees, political risk insurance, and diversification across different asset classes and jurisdictions. Crucially, this approach prioritizes educating the client about the inherent risks and the limitations of full protection, ensuring informed consent and realistic expectations. This aligns with the Alabama Securities Act's emphasis on investor protection and the fiduciary duty to act in the client's best interest, which necessitates transparency about risks and diligent efforts to secure investments. An approach that focuses solely on maximizing returns without adequately addressing the specific risks of the target country is professionally unacceptable. This fails to uphold the duty of care and diligence required under Alabama law, as it prioritizes profit over the client's security. Similarly, relying on generalized assurances from foreign entities without independent verification or risk mitigation strategies demonstrates a lack of due diligence and exposes the client to undue harm. Furthermore, failing to clearly articulate the residual risks to the client, even after implementing mitigation measures, constitutes a breach of the duty of full disclosure and informed consent. Professionals should employ a decision-making process that begins with a thorough understanding of the client's risk tolerance and investment objectives. This should be followed by an in-depth analysis of the specific risks associated with any proposed international investment, drawing upon reliable sources and expert advice. Mitigation strategies should be developed and clearly explained to the client, along with an honest assessment of the remaining risks. The ultimate decision should be a collaborative one, based on the client's informed consent and the advisor's professional judgment that the investment, with appropriate safeguards, aligns with the client's best interests and the regulatory requirements for investor protection in Alabama. Question 16. Research into the investment portfolio of a prominent Alabama-based pension fund reveals a significant holding in a manufacturing company with a history of environmental noncompliance and labor disputes. The fund's investment advisor, operating under Alabama law, is aware of these issues but has primarily focused on the company's strong historical dividend payouts and projected earnings growth. The advisor is now considering whether to increase the fund's exposure to this company. What is the most responsible course of action for the investment advisor? Option A. Conduct a thorough assessment of the company's environmental, social, and governance-esque performance, evaluating how these factors may impact the company's long-term financial stability and reputational risk, and present this analysis alongside traditional financial metrics to the pension fund's trustees. Option B. Increase the investment in the company, leveraging the strong historical dividend payouts and projected earnings growth, while advising the pension fund's trustees that ESG concerns are secondary to maximizing immediate financial returns. Option C. Continue to prioritize the company's historical dividend payouts and projected earnings growth, as these are the primary drivers of investment returns, and there are no explicit Alabama statutes mandating the consideration of ESG factors in this specific investment context. Option D. Divest the entire holding immediately due to the company's documented history of environmental noncompliance and labor disputes, regardless of current financial performance, to avoid any potential association with unethical practices. The correct answer is A. Conduct a thorough assessment of the company's environmental, social, and governance-esque performance, evaluating how these factors may impact the company's long-term financial stability and reputational risk, and present this analysis alongside traditional financial metrics to the pension fund's trustees. Explanation. This scenario presents a professional challenge due to the inherent tension between maximizing investment returns and adhering to evolving corporate social responsibility, CSR, expectations within the Alabama investment landscape. Investors are increasingly scrutinizing the non-financial impacts of their investments, requiring investment professionals to navigate complex ethical considerations alongside fiduciary duties. The challenge lies in balancing the legal obligation to act in the best financial interests of clients, with the growing demand for investments that align with ethical and sustainable principles, particularly in a jurisdiction like Alabama, where specific CSR disclosure mandates might be less explicit than in some other regions, but where general principles of good corporate governance and investor protection still apply. The best professional approach involves proactively integrating CSR considerations into the investment analysis and decision-making process, even in the absence of explicit Alabama statutory mandates for such integration. This means conducting thorough due diligence on a target company's CSR policies, practices, and reported impacts, and considering how these factors might affect long-term financial performance, reputational risk, and alignment with client values. This approach is correct because it anticipates future regulatory trends, aligns with evolving investor expectations, and can mitigate potential risks associated with companies that exhibit poor CSR performance. It also demonstrates a commitment to responsible investment stewardship, which, while not always codified in specific Alabama statutes for every investment context, is increasingly becoming a standard of professional practice and can be indirectly supported by general principles of investor protection and fiduciary duty. An approach that solely focuses on maximizing short-term financial returns without considering the target company's CSR performance is professionally unacceptable. This fails to acknowledge the potential for CSR issues to translate into significant financial risks, such as regulatory fines, reputational damage, or operational disruptions, which can negatively impact investment value. It also disregards the growing demand from clients for investments that reflect their ethical values, potentially leading to client dissatisfaction and loss of business. Another professionally unacceptable approach is to dismiss CSR concerns entirely, arguing that they are outside the scope of investment management due to a lack of specific Alabama legislation mandating CSR reporting or integration for all investment types. This is a narrow interpretation that ignores the broader ethical responsibilities of investment professionals and the increasing materiality of CSR factors to investment performance. It also fails to recognize that, while specific mandates may be absent, general principles of prudent investment and risk management implicitly require consideration of all factors that could materially affect an investment's value. Finally, an approach that selectively incorporates CSR considerations only when they directly and immediately enhance short-term financial returns, while ignoring potential negative CSR impacts or positive impacts that may materialize over a longer horizon, is also professionally flawed. This opportunistic application of CSR principles lacks the holistic and forward-looking perspective required for responsible investment. It prioritizes immediate gains over long-term sustainability and ethical alignment, potentially exposing clients to hidden risks and failing to meet the broader expectations of responsible investment. Professionals should adopt a decision-making framework that begins with understanding client objectives, including any stated preferences for ethical or sustainable investments. This should be followed by a comprehensive due diligence process that incorporates both traditional financial analysis and a robust assessment of a company's CSR performance and risks. This assessment should consider factors such as environmental impact, labor practices, governance structures, and community relations, and evaluate how these might affect the company's long-term viability and financial performance. Regular review and adaptation of investment strategies based on evolving CSR trends and regulatory landscapes are also crucial. Question 17. Benchmark analysis indicates that an Alabama-based investment firm is considering advising a foreign investor on establishing a new manufacturing facility within the state. The firm has identified potential sites and is evaluating the regulatory environment. The foreign investor has expressed concern about potential discriminatory treatment compared to domestic investors or investors from other foreign nations. What is the most prudent course of action for the Alabama investment firm to ensure compliance with national treatment and most favored nation principles? Option A. Assume that general federal trade agreements automatically ensure fair treatment for all foreign investors in Alabama, and proceed with advising the foreign investor based on this assumption without further state-specific due diligence. Option B. Focus primarily on identifying the most economically advantageous locations and incentives for the foreign investor, prioritizing rapid investment without a detailed examination of potential discriminatory implications for foreign investors compared to domestic ones or those from other countries. Option C. Conduct a comprehensive review of applicable federal international trade agreements and U.S. federal laws that incorporate national treatment and most favored nation principles, and then investigate how these principles are implemented and interpreted within Alabama's specific legal and administrative framework, including any state-specific regulations or customary practices that might affect foreign investors. Option D. Rely on informal advice and past practices observed in similar investment scenarios within Alabama to guide the foreign investor, without verifying the current legal standing or explicit alignment of these practices with national treatment and most favored nation obligations. The correct answer is C. Conduct a comprehensive review of applicable federal international trade agreements and U.S. federal laws that incorporate national treatment and most favored nation principles, and then investigate how these principles are implemented and interpreted within Alabama's specific legal and administrative framework, including any state-specific regulations or customary practices that might affect foreign investors. Explanation. Scenario analysis. This scenario presents a professional challenge for an Alabama-based investment firm dealing with foreign direct investment. The core difficulty lies in navigating the principles of national treatment and most favored nation, MFN, treatment within the context of Alabama's specific regulatory environment, which, while influenced by federal international trade agreements, also has its own considerations for business operations and investment. Ensuring compliance requires a nuanced understanding of how these international principles translate into practical application and how they interact with any state-specific regulations or customary practices that might affect foreign investors. The firm must balance the desire to attract foreign capital with the imperative to treat all investors fairly and without undue discrimination. Correct approach analysis. The best professional approach involves a thorough review of Alabama's investment landscape, considering both federal commitments under international agreements to which the United States is a party and any state-specific laws or administrative practices that might impact foreign investors. This approach prioritizes understanding how national treatment obligations, which require treating foreign investors and their investments no less favorably than domestic ones, and MFN obligations, which require treating investors from one foreign country no less favorably than investors from any other foreign country, are implemented and enforced in Alabama. It involves seeking clarity on whether existing Alabama laws or practices inadvertently create discriminatory conditions for foreign investors or offer preferential treatment to certain foreign investors over others, thereby potentially violating these principles. This proactive and comprehensive due diligence ensures that the firm's actions and advice align with both the spirit and the letter of international investment law as applied within the U.S. federal system and its implications for Alabama. Incorrect approach is analysis. One incorrect approach would be to assume that general federal trade agreements automatically dictate all aspects of foreign investment treatment at the state level without further investigation. This overlooks the potential for state-specific nuances or the practical application of federal principles within the state's unique economic and legal context. It risks misinterpreting or inadequately applying national treatment and MFN principles, potentially leading to unintentional discriminatory practices. Another incorrect approach would be to focus solely on attracting investment without adequately considering the fairness and non-discriminatory aspects of treatment for foreign investors. This could lead to practices that, while seemingly beneficial for economic growth, might inadvertently violate national treatment or MFN obligations by creating preferential conditions for certain foreign entities, or by treating foreign investors less favorably than domestic ones in comparable situations. A third incorrect approach would be to rely on anecdotal evidence or past practices without verifying their current legal standing and consistency with national treatment and MFN principles. Investment laws and their interpretations can evolve, and relying on outdated or informal understandings can lead to noncompliance and legal challenges. Professional reasoning. Professionals advising on international investment in Alabama should adopt a systematic approach. This begins with identifying the relevant international agreements and U.S. federal laws that embody national treatment and MFN principles. Subsequently, they must investigate how these principles are practically applied and interpreted within Alabama's specific legal and economic environment. This includes examining state statutes, administrative rules, and relevant case law. When faced with ambiguity, seeking expert legal counsel specializing in international trade and investment law, particularly as it pertains to U.S. states, is crucial. The decision-making process should always prioritize adherence to non-discrimination and equal treatment, ensuring that all investment activities are conducted with transparency and a clear understanding of their implications under both federal and state frameworks. Question 18. The evaluation methodology shows that a technology firm based in Germany is planning a substantial direct investment to establish a manufacturing facility in Alabama. The firm has completed its internal due diligence regarding market opportunities and economic incentives, but has not yet initiated any formal registration or procedural steps with the state of Alabama. They are operating under the assumption that their existing European corporate registration and a general understanding of international business law are sufficient to commence operations. What is the most appropriate procedural course of action for the German firm to ensure compliance with Alabama's regulatory framework for foreign investment? Option A. Proceed with setting up the manufacturing facility and begin operations, assuming that any necessary registrations can be handled retroactively once operations are underway and revenue is being generated. Option B. Rely solely on the advice of their German legal counsel to interpret and comply with any applicable U.S. federal laws, believing that state-specific registration is a secondary concern. Option C. Immediately contact the Alabama Secretary of State's office to inquire about the specific registration requirements for foreign corporations seeking to establish a physical presence and operations in Alabama, and consult with legal counsel experienced in Alabama business law to navigate the filing process. Option D. Initiate a broad inquiry with various U.S. federal agencies regarding international investment, without specifically focusing on Alabama's state-level procedural requirements. The correct answer is C. Immediately contact the Alabama Secretary of State's office to inquire about the specific registration requirements for foreign corporations seeking to establish a physical presence and operations in Alabama, and consult with legal counsel experienced in Alabama business law to navigate the filing process. Explanation. The evaluation methodology shows that navigating the procedural rules for international investment in Alabama requires a meticulous understanding of both state and federal frameworks, particularly concerning the registration and disclosure obligations for foreign entities. This scenario is professionally challenging because it involves a foreign company seeking to establish a significant operational presence in Alabama without fully grasping the distinct procedural requirements that differ from their home jurisdiction. The potential for non-compliance carries substantial legal and financial penalties, underscoring the need for careful judgment. The correct approach involves proactively engaging with the Alabama Secretary of State's office and potentially seeking counsel familiar with Alabama's business registration statutes and any relevant federal securities laws that might apply to the investment structure. This ensures that all necessary filings, such as a certificate of authority for foreign entities and any required disclosures under Alabama law, are completed accurately and within statutory deadlines. This approach is correct because it directly addresses the procedural requirements mandated by Alabama law for foreign businesses operating within the state, thereby ensuring legal compliance and mitigating risks. It aligns with the principle of due diligence and adherence to state-specific corporate governance and registration procedures. An incorrect approach would be to assume that the registration procedures in the foreign company's home country are sufficient for operating in Alabama. This fails to recognize that each state has its own distinct legal framework for business registration and operation. Regulatory failure here is a direct violation of Alabama's statutory requirements for foreign entities, potentially leading to penalties, inability to enforce contracts in Alabama courts, and other legal impediments. Another incorrect approach would be to proceed with operations based solely on general advice from international legal counsel, without verifying specific Alabama state requirements. While international counsel may be knowledgeable about global practices, they may not possess the granular, up-to-date knowledge of Alabama's specific procedural rules and filing requirements. This approach risks overlooking critical state-level mandates, leading to procedural noncompliance and potential legal repercussions. A professional reasoning framework for such situations involves a multi-step process. First, identify the specific jurisdiction, Alabama, and the nature of the business activity. Second, research the relevant state statutes and administrative rules governing foreign entity registration and operation in Alabama, consulting official government resources like the Alabama Secretary of State's website. Third, if the investment involves securities or complex financial instruments, assess potential federal regulatory implications. Fourth, engage local counsel or specialized advisors with expertise in Alabama business law to ensure all procedural steps are correctly understood and executed. Finally, Maintain thorough documentation of all filings and communications to demonstrate compliance. Question 19. Quality control measures reveal that a potential investment opportunity in a manufacturing facility located in a developing nation, identified by an Alabama-based investment firm, may be linked to allegations of poor labor conditions and environmental degradation. The firm's internal due diligence report highlights these concerns, alongside strong projected financial returns. As an investment advisor operating under Alabama's regulatory framework for international investments, what is the most ethically and legally sound approach to proceed? Option A. Investigate the allegations further but only through the target company's provided documentation and internal reports, without engaging external verification or local community input. Option B. Make a partial investment while simultaneously initiating a broad, non-specific inquiry into the company's labor and environmental practices, with the expectation that issues will be resolved post-investment. Option C. Conduct a comprehensive human rights due diligence assessment, engaging with independent experts and local stakeholders to thoroughly evaluate the allegations and identify potential mitigation strategies before making a final investment decision. Option D. Proceed with the investment, relying on the target company's assurances of compliance and focusing primarily on the projected financial returns, as the allegations are not definitively proven. The correct answer is C. Conduct a comprehensive human rights due diligence assessment, engaging with independent experts and local stakeholders to thoroughly evaluate the allegations and identify potential mitigation strategies before making a final investment decision. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the pursuit of investment opportunities with the imperative to uphold human rights standards, as mandated by Alabama's regulatory framework and international investment law principles. The investment advisor must navigate potential conflicts between maximizing returns and ensuring that the investment does not contribute to or benefit from human rights abuses. A complex ethical and legal tightrope. Careful judgment is required to identify and mitigate these risks effectively. Correct approach analysis. The best professional practice involves conducting a thorough human rights due diligence assessment prior to committing to the investment. This approach aligns with the principles of responsible investment and Alabama's commitment to ethical business practices. Specifically, it requires identifying potential human rights risks associated with the target company's operations, supply chain, and the broader socioeconomic context of the investment location. This due diligence should inform the decision-making process, potentially leading to the negotiation of specific human rights protective clauses in the investment agreement, or, if risks are unmitigable, the decision to forego the investment altogether. This proactive stance is ethically sound and legally prudent, aiming to prevent complicity in human rights violations and uphold the reputation of the investor and Alabama's investment landscape. Incorrect approaches analysis. One incorrect approach involves proceeding with the investment based solely on projected financial returns, disregarding the human rights concerns raised by the due diligence report. This fails to adhere to the ethical obligations and potential legal liabilities associated with facilitating investments that may be linked to human rights abuses. Another incorrect approach is to rely on the target company's self-assessment of its human rights compliance without independent verification. This approach is insufficient as it lacks the rigor necessary for robust due diligence and could lead to overlooking critical issues. Finally, an approach that involves making only superficial inquiries about human rights practices without a structured assessment or follow-up is also professionally unacceptable. This demonstrates a lack of commitment to responsible investment principles and leaves the investor vulnerable to reputational damage and potential legal repercussions. Professional reasoning. Professionals in Alabama should adopt a decision-making framework that prioritizes a comprehensive understanding of potential human rights impacts. This involves integrating human rights considerations into every stage of the investment process, from initial screening to ongoing monitoring. When faced with potential risks, professionals should engage in a structured risk assessment, explore mitigation strategies, and be prepared to disengage from investments where human rights concerns cannot be adequately addressed. This approach ensures compliance with ethical standards and fosters sustainable, responsible investment practices. Question 20. Strategic planning requires Alabama-based investors to understand the nuances of international investment law. An Alabama company, Southern Solar Solutions, invested heavily in a solar energy project in a country that has a bilateral investment treaty, BIT, with the United States, which Alabama investors can rely upon. The host country, citing a need to diversify its energy sources and promote domestic industries, enacted new regulations that significantly increased the cost of importing solar panels and components, making Southern Solar Solutions' project economically unviable. The company estimates its projected profits will be reduced by 70% over the project's lifespan, and the market value of its investment has decreased by 50% due to these new import duties. The BIT contains standard provisions for fair and equitable treatment, FET, and prohibits expropriation without prompt, adequate, and effective compensation. Southern Solar Solutions believes the new regulations, while not a direct seizure of assets, constitute a breach of FET. To assess the potential claim, calculate the estimated total financial loss for Southern Solar Solutions, assuming an initial investment of $50,000,000,000 and a projected total return, net of all costs before the new regulations, of $$120,000,000 over the project's life. Option A. The estimated total financial loss is $35,000,000,000, calculated as the 50% reduction in the investment's market value, $25,000,000,000, plus the 70% reduction in projected profits, $35,000,000,000, minus the initial investment. Option B. The estimated total financial loss is $60,000,000,000, calculated as the 50% reduction in the investment's market value, $25,000,000,000, plus the 70% reduction in projected profits, $35,000,000,000. Option C. The estimated total financial loss is $60,000,000,000, calculated as the 70% reduction in projected profits, $84,000,000,000, minus the 50% reduction in market value, $25,000,000,000. Option D. The estimated total financial loss is $84,000,000,000, calculated as the 70% reduction in projected profits, $84,000,000,000. Correct answer is B. The estimated total financial loss is $60,000,000,000, calculated as the 50% reduction in the investment's market value, $25,000,000,000, plus the 70% reduction in projected profits, $35,000,000,000. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent ambiguity in interpreting fair and equitable treatment, FET, under an investment treaty, particularly when a host state's regulatory actions, while seemingly for a public purpose, have a disproportionate and detrimental economic impact on a foreign investor. The investor's reliance on a stable regulatory environment, coupled with the state's sovereign right to regulate, creates a tension that requires careful legal and economic analysis. The challenge lies in quantifying the economic impact and assessing whether the state's actions, even if not a direct expropriation, fall short of the international standard of FET. Correct approach analysis. The best professional approach involves a detailed quantitative assessment of the direct and indirect economic losses incurred by the investor due to the regulatory changes. This includes calculating the diminution in the value of the investment, lost profits, and any sunk costs that are now unrecoverable. This approach is correct because it directly addresses the economic dimension of a potential FET claim. Under Alabama's interpretation of international investment law principles, particularly as reflected in common treaty provisions, FET often encompasses a requirement for the host state to provide a stable and predictable legal and economic environment. A significant, uncompensated economic detriment caused by regulatory action, even if not a physical taking, can constitute a breach of this obligation. The quantitative analysis provides concrete evidence to support a claim that the host state failed to treat the investment in a manner that is fair and predictable, thereby violating the FET standard. This involves applying established valuation methodologies to determine the financial impact, such as discounted cash flow, DCF, analysis to estimate lost future earnings, or asset-based valuations to determine the reduction in the investment's market value. Incorrect approach is analysis. One incorrect approach is to solely focus on whether the regulatory changes constitute a direct physical expropriation or a de facto taking of the investment. This is flawed because investment treaties, including those Alabama might adhere to through its international agreements, often define FET more broadly than just outright confiscation. Regulatory actions that, while not seizing assets, effectively destroy the economic value of an investment, can still violate FET. Ignoring the economic impact and focusing only on the absence of a physical taking misses a significant avenue for a claim. Another incorrect approach is to assume that any regulatory change enacted for a legitimate public purpose, such as environmental protection, automatically shields the host state from liability, regardless of the economic consequences for the investor. While public purpose is a relevant consideration, it does not provide an unfettered right to inflict severe economic harm on foreign investors without compensation or due process. The proportionality of the measure and its impact on the investment are crucial. This approach fails to acknowledge that even legitimate regulatory actions must be conducted in a manner that respects the FET standard, which includes considerations of transparency, reasonableness, and the avoidance of arbitrary or discriminatory treatment that leads to substantial economic loss. A further incorrect approach is to rely solely on the investor's subjective perception of unfairness or the general economic downturn in the sector without concrete, quantifiable evidence of the regulatory action's specific impact on their investment. While investor sentiment is important, legal claims, especially those involving economic damages, require objective and verifiable data. This approach lacks the rigor necessary to establish a breach of international investment law and fails to demonstrate a causal link between the state's actions and the investor's losses. Professional reasoning. Professionals should approach such situations by first identifying the relevant investment treaty provisions and any accompanying Alabama-specific interpretations or case law. A thorough factual investigation is then required, focusing on the specific regulatory actions and their direct and indirect consequences. Crucially, a quantitative economic analysis should be undertaken to measure the financial impact on the investment. This involves employing standard valuation techniques to determine the loss of value, lost profits, and other quantifiable damages. This data-driven approach allows for a robust assessment of whether the host state's actions have breached the FET standard, providing a solid foundation for any subsequent legal or negotiation strategy.